Count 2, rape, felony of the first degree, in violation of Revised Code Section 2907.02A1B. Count 3, rape, a felony of the first degree, in violation of Revised Code Section 2907.02A1B. On that same date, in the 2024 case, the defendant pled guilty to Count 1, pandering obscenity involving a minor or impaired person, a felony of the second degree, in violation of Revised Code Section 2907.321A1 with an attached forfeiture specification. The court found the defendant guilty in both cases and ordered that the probation department conduct a pre-sentence investigation and reports. Court also ordered a victim impact statement. The state has had the opportunity to review these reports and is prepared to proceed with sentencing. Thank you.
All right, Ms. Fagazio.
Thank you, Your Honor. Your Honor, I did submit a sentencing memorandum in these two case numbers. I would ask the court to allow me to incorporate that as part of my statement here today. I also submitted a letter from Mr. Bernstein's mother to the court, as well as a mitigation report from Dr. Arcangela Wood. And I know that Your Honor did receive both of those as indicated in chambers. Your Honor, I would ask this court to take into consideration.
Before we, well, I've got to read him the explanation of duties to register, so let's do that first, and I'll let you get on with this.
Yes, Your Honor, thank you.
All right, so Mr. Bernstein, I'm going to read you this explanation of duties to register as a sex offender, and then give it to you or give it to your counsel and ask you to sign it acknowledging you received this information. You've been, the conviction is in Lake County 23, CR 816, 24, CR 799. Last name Bernstein, first name Daniel, expected residence address 38450 Oak Hill Lane, number 3, Willoughby. You've been convicted of or pleaded guilty to a sexually oriented offense and or child victim offense as defined in 2950.01, and you are designated as a Tier 3 sex offender / child victim offender registrant. You are required to register in person with the sheriff of the county in which you establish residency within 3 days of coming into that county, or if temporarily domiciled for more than 3 days. You are also required to register in person with the sheriff of the county in which you establish a place of education immediately upon entering into that county. If you establish a place of education in another state but maintain a residence or temporary domicile here, you are also required to register in person with the sheriff or other appropriate official in that other state immediately upon coming into that state. You are also required to register in person with the sheriff of the county in which you establish a place of employment, or if you've been employed for more than 3 days or for an aggregate of 14 days in a calendar year. If you establish a place of employment in another state but maintain a residence or temporary domicile here, you are also required to register in person with the sheriff or other appropriate official in that other state if you have been employed for more than 3 days or for an aggregate of 14 days in a calendar year. Employment includes volunteer services. You are required to provide to the sheriff temporary lodging information, including address and length of stay, if your absence will be for 7 days or more. After the date of initial registration, you are required to periodically verify your residence address, place of employment, and or place of education in person at the county sheriff's office no earlier than 10 days prior to your verification. If you change residence address, place of employment, and or place of education, you shall provide written notice of that change to the sheriff with whom you most recently registered and to the sheriff in the county in which you intend to reside or establish a place of employment and or place of education at least 20 days prior to any change and no later than 3 days after change of employment. If the residence address change is not to a fixed address, you shall include a detailed description of the place or places you intend to stay, and no later than the end of the first business day immediately following the day you obtain a fixed address, you must register with the sheriff that fixed address. You are further advised, in accordance with federal law, you must report any international travel to your registering authority no less than 21 days prior to travel. Failure to do so may subject you to criminal prosecution. You shall provide written notice within 3 days of any change in vehicle information, email address, internet identifiers, or telephone numbers registered to or used by you to the sheriff with whom you have most recently registered. Depending on your designation, you are required to comply with all of the above described requirements, in this case under Tier 3, for your lifetime with in-person verification every 90 days. Since your expected residence address, as stated above, is Lake County, you shall register in person no later than 3 days after release with the Lake County Sheriff's Office at 104 East Erie Street, Painesville, Ohio. Fail to register, fail to verify residence at the specified times, or fail to provide a notice of change in residence address or other required information as described above will result in criminal prosecution. And I'll ask you to acknowledge that you've been informed of the above requirements and sign the document. Ms. Vergasio.
Thank you, Your Honor. Your Honor, as I had briefly started to say, I did submit various items that I know Your Honor acknowledged receiving. And I would ask the court in fashioning sentence here today to consider the following additional information. Mr. Bernstein recognizes that this situation and these offenses are the result of terrible conduct that he committed. There's no other way to put that, and importantly, Mr. Bernstein does not wish to put it any other way. He recognized the trauma and the pain that he caused to the victim in this matter, as well as to her family, which is also his family. He recognizes that he caused a lot of people very significant harm and trauma in this situation. Mr. Bernstein showed that he recognized this, and he acknowledged that specifically by accepting full responsibility. He pled guilty in this matter at a pretrial hearing. He pled to the highest charges that he was facing at an early point in this case's procedural posture. And when he entered his plea to those charges, I would point out those are 3 charges that subject him to the possibility of either life without parole or 15 years to a life sentence, plus an additional possibility of an indefinite sentence of 8 to 12 years on the felony of the 2nd degree. And he pled to those charges knowing that the state was going to be asking for the maximum sentence here. Yet he did still accept responsibility at that early stage. He did not wish to put the victim nor any family through any more of the trauma and stress that had already occurred. He recognized that having a trial or having any further proceedings would further exacerbate the situation that was already, as I indicated, a horrible situation, which he does recognize. I would point out that Mr. Bernstein did himself suffer from a chaotic childhood. It's certainly not an excuse for what happened here, and he is certainly not here today making any excuses. But I think it is important to point out that he did himself have some significant challenges. He had no stability growing up. He did witness violence in the home. Again, that doesn't excuse the behavior here, and he does accept responsibility for what he has done. I would ask the court to fashion a sentence here that does give him the opportunity to go before the parole board after an amount of time in order for them to determine whether he has in fact spent the time in prison bettering himself, taking advantage of treatment opportunities that may be there in the prison. He does recognize that prison is required in this case. There's certainly the need for punishment here. But I would ask the court to consider allowing him the chance to rehabilitate, to take advantage of his time in prison, to gain insight, to continue treating his depression issues, and to take classes related to not only the sex offender situation, but also learning about the impact on victims and bettering himself in that manner. So I would ask the court to take all of that into consideration. To also consider that Mr. Bernstein has been incarcerated for over a year altogether while this matter has been pending. And he has used that time to reach out to mental health resources while in the jail to attempt to begin to better himself. So I would ask the court to consider all of that, to give him the opportunity at a sentence that does allow him to go before the parole board, where he would, again, have to show them that he has made progress, that he is someone who should be released into society at that point. And I would point out that if that were to happen, he would still be monitored at that point. He would still have prison hanging over his head. He wouldn't just be free and clear after he would be released on parole if he were in fact released on parole. It is something that is challenging for prisoners to be able to get parole. They're often denied parole the first time that they even appear before the parole board. So I would ask the court to take all that into consideration and to give Mr. Bernstein a sentence here of 15 years to life in prison so that he would have the opportunity to rehabilitate. Thank you.
Mr. Bernstein, what do you want to tell me before I impose sentence?
Your Honor, Mr. Bernstein would stand on the information that he did provide in the pre-sentence report at this time.
Well, it's rather curious. So, as you related to Ms. Wehagen in your pre-sentence interview, you said you took her out of a bad situation, and that's sort of it. You advised her that you do not have detail. You advised her that the victim is your cousin. She was 4 years old when she started living with you. Prior to that, she was staying with her grandfather, Kerry Kaplowitz, who was also your uncle. Told Ms. Wehagen that Kerry lost his apartment and was living in a storage unit. It had no interior bathroom, which concerned you. Later, Kerry's partner, and the victim moved into another place which was still small. You told Ms. Wehagen you, quote, saw a bad recipe in this because you grew up with Kerry and knew that he did stuff to his daughter, Emily. You had the victim over for a sleepover while Kerry was staying at a hotel. That was when you felt that you knew that your uncle was doing stuff, your words, to the victim. You called Emily over to discuss that Kerry was doing this. You claim that Emily knew it, and that's why she let the victim stay with you. Bad bet on her part, huh? And then, according to you, Emily just left the victim with you, that you were not expecting to have the child with you the rest of your life. You stated you did not know what you were expecting. When Ms. Wehagen asked how long before inappropriate things occurred between you and the victim, you said you do not know. When she asked you if you knew the offenses were wrong, you said you knew it was wrong when it was going on before, meeting with Kerry, which is why you got the victim out of her grandfather's house. What a noble gesture on your part. He told Ms. Wehagen that you were teaching her it was wrong. She asked you to explain what that means. And you said if the victim was acting inappropriate, you would tell her, that's not right, don't do that. The 4-year-old came on to you. You said you were not trying to cross the lines, but you were trying to teach her too. And you told Ms. Wehagen that you got yourself into a bad problem and it was too late. You realized that having a kid in your care acting weird would have people think it was you. Maybe because it was you. You recall being approached by a store employee who had seen the victim's unusual behavior. You did not know what to say to this employee besides that it was a problem that they were working on. When Ms. Wehagen asked you how you got from correcting the victim's behavior to raping her, you replied, I don't know. So, and then you've got the pandering obscenity charge with all kinds of stuff on your devices. So it's clear to me that this, based on the information I see in the pre-sentence report, that this wasn't necessarily new behavior to you, or at least you had attempted such behavior before. Whether you were successful or not doesn't seem that you were. But you saw an opportunity with a 4-year-old, and you took it. And you saw the perfect opportunity. You're a very manipulative and cunning person. You saw that opportunity, and you saw an opportunity to blame somebody else for what was happening, and you were going to come in and save the day. You took advantage of this girl's mother because of her personal problems going on, and you saw the perfect opportunity, and you took it. And in the course of this case, there was a request to determine the competency of the victim, which gave me an opportunity to sit down and talk with her. A very bright girl with a very good personality, despite what you did to her. But what you did to her, from what I've seen in 10 years on these type of cases, unparalleled. How vile and disgusting your actions were to this girl who was 4, 5, 6 years old at the time. Now, what makes somebody do that to a helpless child? I can't even begin to understand. And I don't know what you're thinking other than this nonsense that you were spouting to Megan through the course of this pre-sentence interview, because you have the opportunity, and listen, you can say anything you want, you can say nothing. I don't care, it doesn't matter to me. Okay, I don't hold that against you for not saying anything, and I don't hold it against you for saying whatever you say. Okay, that's all part of what needs to be done here. But I cannot think of any explanation why anybody would ever do this to a child. And you worked your way right into that situation and got exactly what you wanted. And you did what you did. And you would have kept doing it. Because as I recall, when the victim's mother managed to work her way through her own personal problems and asked you to return her daughter to her, you resisted. You went so far as to filing an action to, I think, get custody, if I remember right, okay? And then asked for visitation. You didn't want to give up. You didn't want to give up your diabolical situation that you had going. Now, there's nothing in that mitigation report that I read that even begins to explain why you would do what you did. So while you, Ms. Ragazione has indicated that you've accepted responsibility, in fact, you haven't accepted responsibility. There's nothing in that report, there's nothing in your interview with Ms. Wehagen that tells me that you've accepted responsibility for anything. I don't sense that you're capable, from everything I've read, of accepting responsibility for anything.
Your Honor, may I briefly respond?
What?
May I briefly respond?
Sure.
I do think it's important to point out that in the pre-sentence report, Mr. Bernstein did also indicate that he does feel really bad about what happened. He would take it all back if he could fix it, he would.
Well, he can't. He can't take it back, and he can't fix it.
Yes, Your Honor, but I do think it's important to point out that he did acknowledge that. He acknowledged that saying sorry is just a word. It doesn't actually change anything. So he has shown insight there. He has shown that he does think about these things, and he is beginning to gain that insight and move forward. I would also like to point out that he did suffer a traumatic brain injury as a teenager as a result of a car accident.
I'm aware of that.
I'm sorry?
I'm aware of that. It's in the report.
Yes, so I do think that was noted in the mitigation report, and that was something that was discussed as kind of explaining in some ways the way that he does present and things of that nature. So I did just want to point those things out.
Thank you.
Thank you.
Now, the car accident and the injury 20, 24, 25 years ago didn't prevent him from hatching this plan and executing this plan to get what he wanted over the course of about 2 to 3 years. So he can't fall back on that excuse that it had something to do with doing why he did what he did. I mean, I think it's the exact opposite. It showed he had the ability to manipulate that girl's mother, to manipulate Kaplowitz, to then point the finger at Kaplowitz, ingratiate himself with the girl's mother, and then repeatedly rape her over a period of time. So there's nothing in that report. Certainly nothing excuses it. I don't think you're insinuating that it excuses anything. But
No, Your
there's
Honor.
nothing in there that explains it.
Well,
There's
my client's
But
exactly the opposite. I mean,
Right.
he's certainly saying there is no excuse for his behavior.
Right.
That's correct.
and there's no explanation for it. I mean, the report says what it says. But there's certainly no insight as to why he did what he did. Now, the fact is that this young girl, and part of what I received was the victim impact statement penned by the victim's mother, which describes the victim's current situation. And you can be assured that this is never going to leave her mind, ever. She's going to think about this on a daily basis. She's going to have to try to figure out how to live with it. That's the best she can. And I don't know how she does that. Because just because of you and your selfishness. That's the only reason for it. And then you get to all these images that were on your electronic devices. And you got a whole host of other victims who, if not for people like you, those pictures wouldn't exist. Because of sick minds like you who observe this stuff and peddle this stuff. That's why there's all this stuff that goes on. That's why all those photos exist. And those victims have no control over anything because of people like you. Mr. Gazione, anything further?
Your Honor, I guess I would just, again, refer to my statements previously and just request that the court consider giving Mr. Bernstein the opportunity to participate in programming in the prison and the opportunity to show the parole board at the appropriate time that he is making progress and fashion a sentence accordingly. Thank you.
Ms. Hronik?
Thank you, Your Honor. The state is requesting that the court impose a sentence of life without the possibility of parole on all 3 counts of rape in the 2023 case, consecutive to each other and consecutive to a prison sentence imposed on the 2024 case for the pandering obscenity involving a minor or impaired person. The state would like to point out that the charged conduct for the pandering case was for pictures of the victim of the rape case that were located in the defendant's phone. There were pictures of his rape victim, and that is what constituted the charged conduct in the pandering obscenity case. The state believes that the maximum consecutive sentence on these cases is appropriate for several reasons. The first of those reasons being the serious physical or psychological harm that the victim suffered. She suffered permanent injuries to her vagina and her anus. She was found to have a fully transected hymen, healed hymen cleft, and a near complete absence of anal folds. These injuries were discovered in an exam that was conducted 2 months after the abuse had stopped. She has also been diagnosed with post-traumatic stress disorder. That was a diagnosis that she received when she was 7 years old. In addition, these physical or mental injuries were exacerbated by her age. She was 4 years old when the rapes began. She was 6 years old when they ended. She was so young that she had no ability to protect herself. Her physical injuries that I mentioned, the injuries to her vagina and her anus, were the result of a grown man pushing his penis into the vagina and anus of a small child. So her small size exacerbated her injuries. And her post-traumatic stress disorder diagnosis will continue to get worse as she gets older. When this was happening, she had no real understanding of what was being done to her. She was too young to be able to have that understanding. And so that mental injury that she suffered was also exacerbated and will continue to be exacerbated by her age. The defendant's relationship with the victim facilitated the offense. The defendant fought to keep the victim from her mother and filed for custody with the courts and won twice. He filed for that custody and he won that custody so that he will be the victim's sole provider, the sole provider of her safety and of her care. For all intents and purposes, he was her parent during this 2-year period. He had complete control over her, and he used that control over her to repeatedly rape her, something he did so often that the victim described it as happening every day. He was only able to commit these crimes because of the unfettered access to the victim that he had fought for and gained by receiving custody. The state does not believe that the defendant feels any genuine remorse. While in the pre-sentence report, he does say all the right words. He says he's truly sorry and he feels ashamed and he accepts full responsibility and he's genuinely remorseful, but he never once acknowledges what he did to the victim. He says he took her in to keep her safe, when really he took her in and he used her for his own gratification for 2 years. I think this is a specific example of this is that the last 2 times that he's reported to have raped her, the victim, was on the day that her mother came to receive her after mom had won custody back. The defendant does not have any remorse for his actions. The state also does not believe there's any mitigation that has been presented. In the pre-sentence report, the defendant mentioned that he has empathy and clairvoyance. He describes clairvoyance as knowing what other people are thinking and how they feel, which, if that is true, then he knew what the 4-year-old that he was raping was thinking and feeling, and he continued to do it anyway. He also blames the traumatic brain injury from a car accident, but yet was able to heavily encrypt all of his digital devices, so much so that only one or two devices was able to be broken into, and one device took the Secret Service to break into. That's how heavily it was encrypted. Some of the devices have not been broken into. I believe that shows that that traumatic brain injury is not a mitigation at all. He does have the ability to understand what he is doing. The state believes that nothing but a maximum consecutive sentence is enough to punish the defendant for what he did. The 3 counts of rape in the 2023 case do not merge. Each count refers to vaginal penetration, anal penetration, and fellatio. All 3 were separate acts and separate harms that were occurring over the time period of 2020 to 2022. The defendant, in his pre-sentence report, states that he hopes for a sentence of 15 to life so he can get out of prison when he's not too old to have a life that he can enjoy. The defendant destroyed the life that the victim could have and would have had. The damage that has been done to her cannot be understated. the harm that was caused by those 3 counts, the actions that took place in those 3 counts was so great or unusual that no single prison term can adequately reflect the seriousness of his conduct. When the victim describes what happened to her, and she does so clearly without understanding the gravity of what she was saying, when she describes not being able to breathe because her head is being pushed into pillows while she's being raped from behind, when she describes turning around and seeing the defendant filming her while this is happening, when she describes the defendant ejaculating on her face after he forces her to perform fellatio, that harm requires a consecutive sentence, and only a consecutive sentence would be necessary to punish the offender. If the defendant is given the opportunity for parole, he is given a life tail, 15 years to life, that would be, in essence, a life sentence for the victim, because starting at when she's 23 years old, and at that point will fully understand what was done to her, she will have to, every few years, endure being forced back into this trauma, going and choosing to either go in front of the parole board and explain what was done to her, or not going and risk him getting out. These rapes occurred over a period of 2 years. They were part of a course of conduct that lasted for 2 years. And the state believes that the defendant with this conduct has forfeited his right to be among free society ever. And so at this point, the state would request that the court impose a maximum consecutive sentence on the 3 rape counts of life without parole, serve consecutive to each other, and serve consecutive to a sentence imposed for the pandering obscenity charge. Thank you.
Trying to figure out why you think you had the right to do that to a girl who was 4 and 5 years old. And the only person who can answer that question is you. But as with Ms. Wehagen, you don't have any desire to talk about this stuff. I've considered all the provisions of 29, 2911, 29, 2912, 29, 2913, and 29, 2914. I've reviewed the sentencing memorandum, the letter from the defendant's mother, the psychological report provided in mitigation, the victim impact statement, consider the contents of the pre-sentence report, most specifically the defendant's statements or lack thereof in the pre-sentence report. This notion of taking responsibility is a curious notion that I hear every day. And while you say that you've taken responsibility because you've pled guilty, you haven't taken responsibility for anything. You'll never take responsibility for anything. On the 24 case, I sentence you to a definite minimum of 8 years up to an indefinite maximum of 12 years in prison with credit for 115 days. On the 23 case on count 1, I'm going to sentence you to a term of life in prison without the possibility of parole. Count 2, life in prison without the possibility of parole. Count 3, life in prison without the possibility of parole with credit for 471 days. Those sentences will be consecutive to one another. And that sentence will also be consecutive to the 24 case. And there's never been a case that I've had where this has been more appropriate. Consecutive sentences are necessary to protect the public from future crime by you and for the appropriate punishment for what you did to this young girl, and they are not disproportionate to the seriousness of your conduct and the danger that you pose to the public. All of these offenses were committed as part of a course of conduct, and the harm caused by these multiple violations of this young girl was so great or unusual that no single prison sentence for the offenses adequately reflects the seriousness of your conduct. So your goal was to get out in 15 years so you could enjoy life. So you could enjoy life. You don't give a damn about that girl, okay? Because she ain't enjoying it. She's not enjoying reliving what you did to her every day over the period of 2 years. But you don't really give a shit about that. You just care about you. You don't take responsibility for anything. Remaining counts are dismissed. Anything further, Ms. Hronik?
Daniel Bernstein has been sentenced to life without parole after a Lake County court reviewed all evidence, reports, and statements. The judge emphasized the severity of the crimes and the calculated nature of his actions. Consecutive sentences were imposed to ensure public safety, reflecting the seriousness of this historic case. Bernstein's Tier 3 status means he will be closely monitored for life, underscoring the court's commitment to justice and protection of the community.